मतलब can it be a Monday, man?
Okay.
Lordship को एक
Monday to BBS.
Oh, Monday I have a DB or something. I was told. Single bench is there after 2, I think.
Yes, man. Obliged.
Same prayer, Lordship, Monday, Lordship.
Lordship, I have also similar plan.
Monday or Tuesday? Okay. Okay.
Yeah, please, Your Lordship. I beg to mention item number 1, Lordship. Kindly pass over for the day, Lordship. That my
Number 1, we have received the case that
Okay. You don't want to do it today? What?
senior is not available for
Not available today.
let it come on my note on
Monday in the single bench?
yes Monday, man. Monday.
In the single bench? You have
Monday,
time.
you would- No, not
CD maybe CD shall be retained. Interim is there.
Interim
right?
is there.
Interim extended.
Tuesday, man.
Tuesday. Okay.
Obliged.
I have a DB. I don't know. I just.
Number 2.
Right, please, Your Lordship. Lordship 482 application.
Application,
For
yes,
NDCP bail, my lord. CD was called for earlier. I am in interim, my lord.
CG not received. Lordship. It is from Gauhati.
The issue reminder for the case diary, interim extended. List on
24/2.
24/2.
Deeply, Your Lord.
Number 3.
CD received but none appearing.
Council is not there. No? We can wait at the end of the day, after the list, we can do it.
Number 4.
Please, Your Lordship. My lord, TCR was called for, my lord, with CD.
Can copy received.
Charge sheeted case.
Charge-sheeted case, my lord. My lord, petitioner is willing to cooperate with the proceeding, my lord. Affair is page, my lord, 15. The translated part is page, my lord. Lord, page 16 is the starting, my lord. Can you see the very first line of paragraph 1, my lord?
Yes, no.
Page 16.
Yes.
My lord, may I read, my lord?
Yes.
My lord, that the information received subsequently on the abatement and instigation of the aforesaid accused number 10, 11, and 12. All other identified accused, including other unidentified accused, forming unlawful gang trespassed in a body, my lord, body into the house of the informant at number 2 Pubergaon on 10/10/2015 at about 1 p.m. and compelling the informant to keep silent at the point of danger, dagger committed dacoity of the below described articles, ornaments, and cash amount by breaking open glasses, lock of wooden almirah, and dressing table in the informant's house in absence of her husband, Abdul Suban Ali, in the house, and went away causing financial loss to the extent of 2,91,200 only, approximately rupees so and so, only approximately to informant and her husband. And on the eve of their departure, the accused threatened the informant not to file any FIR as to this dacoity with the police.
Okay.
My lord, kindly very first what my lord, as receive information received subsequently. So my lord she received information from other sources, not directly my lord.
Whatever it is, the 12 accused persons were named in the FIR, right?
My lord.
And then,
And most of them,
then charge sheet was filed against all of them.
my lord, all of them.
All
my
of
lord.
them.
And most of them were, my lord, arrested and surrendered before the police, and subsequently they released, my lord.
And here one petition.
And the petitioners are the family members of this, my lord, accused, my lord.
They are not named in the FIR, these persons.
Affair, my lord, named in affair, my lord, as accused
And
number,
also
my lord.
charge sheeted.
My lord, also charged, my lord. Accused number, my lord, 8, 9, and 10, my lord.
Okay.
My lord, it's a session tribal case. The petitioner apprehended if they, my lord, if they appear, my lord, they will, my lord, remand before the custody. my lord.
Record is with you.
Yeah, charge sheet submitted on 11/10/15.
15.
Long way back.
Someone issued, my lord, on kindly see the.
And we just issued the petitioner, so they are not
NBW.
cooperating with the investigation at the time, the whole entire investigation. And the turn the trial proceedings into also, it is delayed and stopped only because of them, lordship.
And the accused and the informants are co-villagers, they residing peacefully, my lord, their houses are adjacent to the, my lord, each other. Case 40 is the, my lord, NBW issue, issued by the, my lord, learned, my lord, judicial magistrate, my lord.
There is a subsequent, their name is there, lordship, in the person.
Yes,
They have been charged. Sheet.
What
So what to
my
do?
lord,
after
Otherwise, they could have taken bail from learned court below, but
below.
Sessions Tribunal, that's the thing. No, not Sessions Tribunal. Dacoity is punishable up to 10 years or life.
my lord, one section,
Life,
my lord,
okay.
395 is the section.
Life, life.
Life, my lord, I am relying, my lord, to one Supreme Court judgment.
No,
My lord, one-
I, in my humble submission before lordship, if lordship, they have to appear before our trial court, they want to appear, and trial court will decide on merit, lordship.
My lord, trial court does not have jurisdiction to
Protection,
grant bail, my
here
lord,
it
unless
is
your
seeking
lordship
protection,
direct.
lordship.
If it is punishable with life imprisonment,
Well-
Sessions Tribunal magistrate can also give.
Yes.
We have discussed many times, but if it is it is punishable up to life, then Sessions, this magistrate may not have
My
jurisdiction.
lord,
They very little jurisdiction, 437. Is it punishable up to life? 397. Anyway, M. Islam, Learned Counsel for the petitioners, and DP Goswami, Learned additional P. Invoking 482, the petitioners are seeking anticipatory bail in connection with Mankasar PS case number 620 of 2025, which was registered on the basis of an FIR dated 11/10/2015 itself, alleging dacoity, and in which 12 accused persons, including the present petitioners, were named. The investigation resulted in a charge sheet being CS number 402 of 23 dated 31/7/23 under sections 147, 48, 49, 448, 395 IPC. The corresponding GR is PRC number 418 of 2024. Case is presently at a stage of appearance, and it is submitted that NBWA has been issued against the petitioners by the learned JMFC. It is submitted that several of the charge-sheeted persons were arrested during the investigation, and they are now on bail or on custody.
They are connected.
absconding, my
No,
lord.
they were arrested, you said, no?
No, my lord. Petitioners are all
AB.
No, not petitioners. So
Sir,
other
These
co-accused,
are, my lord.
they are on bail,
My lord,
Hmm?
my lord.
were arrested and now presently on bail. Full stop. The charge sheet was submitted in 2023, said that is several years after about 8 years after the registration of the case.
Four persons are absconding.
These people.
They are.
One absconder is, my lord, I have no.
The learned additional PP submits that perhaps considering the nature of the alleged offences, petitioner may be directed to approach the learned court below. The petitioner counsel submits that perhaps the learned GMFC may not have jurisdiction to grant bail. The interest of speeding up the trial, which is already delayed, I deem it proper to grant bail to the accused persons despite the alleged offences, nature of the alleged offences, but subject to suitable conditions. Accordingly, it is directed that in the event of the arrest, they shall be allowed to go on bail of rupees 30,000, 50,000 each to the satisfaction of the arresting authority. And subject to the conditions that they shall appear before the learned court below on the next and subsequent dates. They shall be available for trial. They shall not hamper or tamper with evidence. They shall be available for trial if one commences. They shall not hamper. They shall not in any manner intimidate, harm, or harass the informant and his family member. They shall not try to intimidate or harm or influence witnesses. Violation of the bail conditions would make the bail liable to be cancelled. The petitioners shall appear before the learned court below and submit bail bonds, fresh bail bonds. And the learned JMFC shall pass suitable orders regarding the same.
So this order should not be precedent for the other cases also, Lordship, because effects are different for other.
Yes, not a precedent.
But-
Disposed, allowed and disposed of. Fully oblige, your lordship. It turns on its facts. Okay, okay.
Item number 3,
Yes, you can come.
Me, please, your lordship. Lordship, it was an anticipatory bail application.
Excavator, right? This matter.
Yes, my lord.
Yes, your lordship.
Excavator
Legal
was
finding, my lord.
found.
But the sections which are inserted here are section 40 and 41 of the Assam Forest Regulation Act 1891. And
40 and 41, right?
yes,
It was 302 subsection 2, 317 subsection 4.
yes.
That is BNS, right?
That is BNS.
And the rest 40, Sibu, 40, 41 are
40,
Assam Forest Regulation.
Forest Regulation.
1891. or-
1891. So, under section 40, the punishment is given under section 41, and it is up to 3 years, lordship. So, this section are bailable in nature.
This is investigation is going on.
Investigation going on, my lord.
Investigation is going on, and moreover, theft and habit.
So he was excavating without permit. He said.
Without permit, my lord.
But your lordship, he has taken permission from the geological department, which I have annexed the document.
I remember.
It is in page 18 to 19, annexure 2. Directorate of Geology and Mining, Bhu Vigyan Bhavan,
Page?
page 18 to 19.
Dipankar Chaudhary. That's okay then.
And the other two.
If there is any criminal case, it will be investigated.
Yes, my lord.
But
Investigation.
his bail can be made absolute. If there
Yes,
is no
my-
other.
Just I'd like to point out
Yeah,
some few
yes.
things, my lord, for consideration, my lord.
Yes, sure.
Here, other sections also, my lord, 303
Cutting out
and
trees and blasting,
3174, my lord,
Mm,
which are IPC sections, my lord.
mm,
And also, my lord, in some cases, my lord, even though it is 3 years, my
Mhm.
lord, but it can be made non-bailable, my lord. It is
Mm.
not that if it is 3 years, it is bailable, my lord, because there are
Special acts are different.
special acts are different, my lord. So that argument may not, my lord, lie here, my lord. And another thing, my
If
lord.
there is no special act, then
Yes,
CRPC, that provision
that
will, in
CRPC
the schedule will.
yes, that is.
Otherwise, but does Forest Regulation Act say that it is non-bailable? That
No,
is, does it say?
uh,
Or is it silent? I'm not sure actually.
actually.
If it is silent, then it will be CRPC.
Yes,
Huh?
yes.
according
And
to
also, my lord,
CRPC.
in some 303, 317, these are not available, my lord. They are not
Yes, yes,
available.
that's okay, no problem.
And my lord, now, he has made his statement before the IO, my lord. That is one thing. And secondly, my lord, whether he has permission to excavate in that area or not, my lord.
Excavate land.
Yeah, land, my lord, mining, sand, my lord.
Sand.
Yes, my lord.
One thing that I noticed is that 12 cutting of trees and blasting is not allowed
Yeah,
under
yeah.
this.
And also, my lord, so my lord, from the DFO report was called for, and DFO, my lord, he has given a report wherein it is stated that no permit has been issued to Dipankar Chaudhary for extraction of minor mineral from Wara area, Kolya River, and no government royalty has been deposited by Dipankar Chaudhary. Secondly, this is second allegation, and third allegation is that already another offense has been registered
Achha.
against him in BR 1082025 in Pathala beat and FIR in Patasa police station, man. So they
Mining
have,
it. Hmm.
yes, 3 things are against him, man.
Just let me see. Have a look.
Yes, and I just have leave it to Allah.
What is, this permission is geology and mining. Yeah?
Geological
This
mining.
excavation permission is given by Forest Department. Forest Department. But what is the role of geology and mining then? Now, what will be the value of this permission then?
Yeah, and that value will not, my lord, suffice, my lord.
No, because this, he is also an authority,
Yeah,
right?
this is under the forest department.
But he is also an authority, no?
Yes,
Director of Geology and Mining.
Yes.
So I think there's a overlap.
Yeah, over. So may kindly see the.
According to annexure 7, that is page number 24, the environment impact assessment also approved, Lordship. Page number 25, annexure 7,
Some disputed facts, I think.
Yes, sir.
approval environment
So let
impact.
them investigate. Let them investigate properly,
Yes.
because Imperial Corporation also,
Yes.
Fire and Services also.
Because there is a
24.
reference of Kalia River in the FIR, my lord, and as per the report.
Where's the environment impact?
Environment impact is page,
24,
page 25.
25.
25, your lordship, annexure 7. The seal of the environment impact assessment approval seal is also there. And about the Kaldia River, that is a something different aspect. His name is not in that particular allegation.
We are not on, neither on trial nor on quashing.
No.
So investigation should be done properly. If any offense is made out, then they can file charge sheet.
Yes.
Otherwise,
Lordship.
it's not necessary to go back and
Because he is ready to cooperate.
arrest.
Lordship. He also recorded his statement.
What might have happened is that he might have exceeded the
Yes,
the permitted area.
Yes,
Actually,
yes,
he has
ma'am.
been given some permit, but he
Yes.
may have exceeded that.
Yes.
Anyway, P. Das, J. Das,
J.
sorry,
Das.
learned counsel for the petitioner, and
MP Goswami.
I know, K. Goswami learned additional P for the state. Last order, second, third paragraph, you can take it, huh? That 41 of forest regulation. The petitioner was granted interim bail on 9/1/2026 with conditions, pursuant to which he is stated to have appeared before the IO for recording his statement. The same is confirmed by the learned additional PP, who has
Yeah.
also received the,
Yes, in the last page.
yes, he is also, who has also received the case there. The Das Learned Counsel, drawing attention to the annexed documents, submits that he has obtained a permission dated 30/10/2025 from the Director, Geology and Mining, Government of Assam. They submitted that relevant permission from Fire and Emergency Services as well as environmental impact assessment approval has also been given to the petitioner. So, however, the prosecution submits that he has not got the relevant permission from the Forest Department. And in the report of the DFO, it is contended that what was the contention
Last 3 lines, Lord, you will find it.
of the
In the report, my lord,
Report.
flag mark, my lord. Flag mark. Last part, my lord.
that no permit has been issued to the petitioner for extraction of minor minerals from Koara area on Kaldia River, nor any government royalty deposited by him.
And thirdly, my
Stop.
lord, one case is pending.
It is also contended another criminal proceeding has been initiated against the petition. Nevertheless, while the investigation proceeds to determine whether the petitioner should be sent up for trial for any criminal offense, it may not be necessary to cancel the interim bail. And I am of the considered view that as his statement has also been recorded pursuant to grant of interim, allowing the bail petition may not prejudice the investigation. In such view of the matter, the interim bail is hereby made absolute, subject to the condition that petitioner shall continue cooperating with the investigation. Number two, he shall not hamper or temporary evidence. He shall not commit any illegal activities or offenses or any activities violative of the forest laws and regulations. Violation of the bail conditions, standard legal. Return back the case diary. Bail petition stands disposed of, allowed and disposed.
Deeply obliged.
Item number 5,
Yes,
Please, Your Lordship.
Oh,
This is a leave petition, Your Lordship,
the petition.
for appeal against equity, Your Lordship.
You are for the private respondent.
Respond number 2.
The leave petition may be disposed of, Your Lordship, and the appeal number may be, appeal will be numbered, Your Lordship.
You're appearing in private capacity.
Private. That's defamation case.
Defamation case, sir. Complaint case, obviously. What is your submission?
Just my objection may be recorded.
Okay. Nazneen, hmm?
Yes, Your Lord.
As Nazneen, counsel for the petitioner, and DK Bhattacharya, learned counsel for respond number 2. MK Goswami, no, like
Respond
the
number
formal party, I think.
Formal-
Complaint case, no issue. Complaint case.
Okay.
Full stop.
But
The
we are made party.
party, yes. MK Goswami for additional. The petitioner is seeking to file an appeal against
Equity.
acquittal by judgment and order dated 24/4/2024, passed by learned additional session just number 5, Kamrup M, in criminal appeal 287 of 17 dash, whereby the judgment of the trial court convicting the respondent or number 2 for criminal defamation and sentencing him with fine, again dash, was set aside with an order of acquittal. What is your contention? There are grounds.
Yes, Your
The
Lordship. Grounds is
learned
that-
counsel submits that the trial court, there was no sufficient justification to overturn the trial court judgment, and assails and that the petitioner wants to assail the appellate judgment passed in appeal. Mr. Bhattacharya objects to grant of bail.
Leave.
Grant of the leave. Peruse the leave petition. Full stop. It's not possible for me. I've not gone into the records now. So anyway, the prayer for leave is allowed, and accordingly, the petitioner is granted leave to prefer the appeal against acquittal. Full stop. The leave petition is allowed and disposed of. The criminal appeal may be registered and put up for admission.
Yes, sir.
I want to actually there will be case laws on what is the parameters of leave. You know? Giving leave order for acquittal.
item number 6,
Obliged.
Legal aid counsel, amicus, right? POCSO matter. He was convicted, right?
Yes, Your Honor. Already 4 years has been passed.
Oh, yes, yes, yes.
And only he has been conviction under section 6 and past judgment was passed on 2022.
Mhm.
And already now it is.
Yes, yes, and those matters are urgent. Anyway, Manisha,
No, your lordship, no objection.
criminal appeal,
Yes,
conviction, let him file. At least one tire should be examined,
Yes, your lord.
because human beings are fallible. Always, they're all infallible, fallible human beings. Therefore, one more tire should be examined. But I'll tell you, let me dictate the order. What we can do is heard as what Mr. Alexei. Sangeeta Khataniar, learned legal aid counsel appearing for the petitioner, seeking condonation of delay of 680 days in preferring a criminal appeal against a judgment and order of conviction dated 29/9/22 was by learned Special Judge POCSO Shivahagar in POCSO case number 45/24. He was sentenced to imprisonment of 4 years.
No, 5 years.
5 years. Full stop. But he is presently in the custody undergoing the sentence. Full stop. Mr. Goswami, M.K. Goswami, learned counsel, additional people. For those things. Submits no objection to the delay condonation. Heard M.K. Brown, learned amicus curiae for the informant. Full stop. He submits that being a judgment of conviction and sentence, and that he has no objection. She fairly submit that she has no objection to grant of to the delay condonation. Generally, some explanation must have been written, no?
Yes, Your Honor, but it is already, the paper book has been received only on the 2025. Already 3 years has been left there in the department. Already.
The explanation for the delay has been narrated in para 2. Full stop. It is contended that the copy of the judgment was received on 29/9/2000 on 10/9/2024. Thereafter, copies were furnished by the Legal Services Committee of this court, and after preparation of the memo of appeal, there was a delay of 680 days. Was it preferred from jail? Something?
Yes, Your Honor.
The petition for seeking appeal was sent from jail by the convict appellant first. In the circumstances, and also considering that petitioner is seeking to assail a judgment of conviction and sentence of imprisonment, the delay, though on the higher side, is hereby condoned. In exercise of powers under 5 Limitation Act, 1963. Good stuff. The IA is hereby allowed and disposed of. The criminal appeal shall be registered and put up for admission. The court records its appreciation for the services of the legal aid counsel and the learned amicus. Okay. And what you do, Sangeeta, what you do is, once it is admitted, you get it fixed on a hearing day at 2.
Yes.
On these matters, we'll do that.
Yes.
Whichever court is there,
Already
make
delay
that submission. Make that submission. These are urgent matters, because
Yes.
hearing day also we are not sure where it depends where it comes. There may be older matters. So get it fixed at 2. It's a best ground. He's already covered a lot of. Either we take up the IA, or best is we dispose of the appeal.
For a legal aid counsel, lots of matters.
Yes, no, because either we take up the IA, or best is we take up the appeal
Yes, sir.
and dispose it off. And if you fix at 2, it will surely reach. That's the best. Okay. Any other?
May I please, your lordship?
Yeah.
Permission for withdrawal of the matter, lordship.
Which matter?
A criminal matter, lordship.
When you want?
Monday, lordship. Highly please. May I please, your lordship? I beg to mention for listing one criminal revision petition, lordship.
Against conviction.
No, lordship, a learned family could pass the judgment
Maintenance.
for maintenance, lordship. Thereafter, petitioner approached before
Mhm.
this court, and this honorable court stayed
Okay, when do you want it?
13 lordship,
Okay.
deeply only.
I have
The-
to